I'm Drew Stevenson, and this is a lecture for my Statutory Interpretation and Regulation class about the famous case Tennessee Valley Authority versus Hill. This is a U.S. Supreme Court case from 1978 about the Snail Darter and the Tellico Dam in Tennessee. And for my students, just as a quick aside, this is a famous case about statutory interpretation and legislation. It's in a lot of case books, and in fact, academic books and studies and stuff have been written just about this case. So TVA v. Hill is a case that you might want to remember or tuck away in your mind. And let's see what happens in this case. And this is a nice way of introducing some of our sort of big ideas for the statutory interpretation part of our course. So we start with the statute, which is the Endangered Species Act as passed in 1973. And the relevant part says, each federal agency shall ensure that any action authorized, funded, or carried out is not likely to jeopardize the continued existence of any endangered species or threatened species that's almost endangered, basically, or result in the destruction or adverse modification of the habitat of such. And so just to be very clear, the Endangered Species Act doesn't just protect endangered animals from poaching or hunting or things like that. It also has a section that says federal agencies are not allowed to fund projects or undertake endeavors that will harm the endangered species or threatened species or their habitat. And this idea of protecting their habitat actually sort of took on a life of its own and is the part of the statute, I think, that generates the most litigation, really, because sometimes we're talking about very large areas of land that can't be used for any type of development or commercial activity because it's a critical habitat for an animal that's been listed as an endangered species. So let's go back to our case. And so the project here is a dam being built by the Tennessee Valley Authority. They're a public works project that kind of came into its own in the New Deal era, partly to create jobs and partly to build infrastructure in rural Appalachia, and functions a lot now as a power company to provide electricity. And so this is a hydropower dam or hydroelectric dam. And the question is whether the Endangered Species Act prohibited completion of the dam, pictured here, the Tellico Dam, which had a price tag of around $100 million. So it was mostly complete. In other words, almost $100 million was spent on it by the time we get to this case. And a lot of that had been spent before the Endangered Species Act was enacted in 1973. And in fact, Congress continued appropriating funds, millions of dollars, towards its completion every year before and after passing the Endangered Species Act. So in 1973, just before the passage of the Endangered Species Act and the completion of the dam, a biology professor discovered a new species of snail darter, and that are little fish like those you see here, a tiny tan-colored fish in the river around where the dam was being built. And so they started a process to have this listed as a new endangered species that had just been discovered. And now that process takes months and months and months drag into years. So it's about 2 years. So by 1975, the Secretary of Interior, and that's the agency who's responsible for putting animals on the endangered species list, lists it as an endangered species. Well, that made the river a critical habitat for those little snail darter fish that I would have called minnows, I guess, when I was a kid. So the TVA and the Secretary of Interior tried various ways to work this out unsuccessfully, because we have an almost completed dam that was very expensive, and now we're just going to have to waste it, right? Like not use it. So they tried experiments with moving some of these little fish to another river and seeing if we could get the population thriving there, and it didn't work, and so forth. So basically the Secretary of the Interior, they reached an impasse and the project was halted for a while. Now, before the impasse happened, while the Snail Darter was going through the certification or listing process, we call it, the TVA was going to Congress and getting more money. And the issue came up. They acknowledged, everybody knew that there was this little fish called the Snail Darter that nobody had ever heard of before. And that if it was listed as endangered, it would mean that this became a critical habitat. And the TVA basically told Congress that was never going to happen, that this fish was not endangered and so forth. So Congress kept giving it, the Tennessee Valley Authority, millions more dollars to put towards the dam. So once we do have the little fish listed, litigation ensues to halt the project. And the trial court sided with the TVA, those are the dam builders, saying that halting a nearly complete project that cost almost $100 million was absurd. And I hope that my students, this calls to memory something called the absurdity doctrine, a common law tool of interpretation or sort of maxim that we talk about in other classes, in other cases. And so Congress then, after that decision came out from the trial court, allocated a few million more dollars for the dam. But then the plaintiffs appealed it to the DC Circuit, and that the DC Circuit Court of Appeals reversed the trial court and enjoined the project. Then we go to the Supreme Court, and the Supreme Court sides with the Circuit Court and the plaintiffs in the case and held that the Endangered Species Act statutory language is clear enough and applies to the dam, so the project has to stop. And the dissent took a contrary view, of course, arguing that the statute didn't really speak about projects that were already underway at enactment. It did grandfather in completed projects; those could continue to operate. It was pretty clear you couldn't start a new one, but it really didn't talk about what to do with something that was half done or mostly done on the day that they passed this statute. Now, here we're going to talk a little bit about legislative history. So if you remember, maybe as a kid, you watched a cartoon called, there was something like, I'm Just a Bill Sitting on Capitol Hill. There's a long process that bills go through before they become a law. And they have to go through the Senate and the House. They go through various committees in the process, and there's a paper trail generated from this whole winding process through different committees and floor debates and so forth. And this paper trail includes little reports and memos and statements and debates and colloquies and so forth. Sometimes it's voluminous and sometimes it's really not much at all. And part of the issue in this case is relying how much we can look to those documents that are produced along the way as we enact a bill, get a bill passed into law, to figure out what Congress really wanted. So they had tried an earlier version of the Endangered Species Act in 1966. Remember the one we're talking about passed in 1973, and it didn't pass. So it comes up again in 1973, and the Senate bill looks a lot like the 1966 one, and it included a qualifier that permitted the agency to take practicability, that's basically financial considerations, into account in preserving endangered species. In other words, the Senate bill had an exception that the Senate's version of the bill that probably would have allowed the Secretary of Interior to give a waiver for the Tellico Dam. But a different version of the same bill was winding its way through the House of Representatives. And this is a very important thing to get straight in this case. When a law is going through Congress, slightly different versions of it are going through each house and get voted on by each house. Then they go to something called the conference committee that merges these, kind of hammers them out to a unified product, which goes back. Each house usually votes on it with a simple thumbs up or thumbs down vote. It almost always goes through. And so this merged, or what they call it, reconciled version of the bills that went through each house, they're very similar, but they have small differences, right? And the merged or reconciled one is what goes to the president for signature or veto. And so the problem here is that The version that went through the Senate had a qualifier that would have allowed for exceptions in extreme cases like the Tellico Dam, and the House bill didn't have that. And then when it comes out of the conference committee, the final version looked like the House bill. It didn't include this qualifying phrase. And now this conference committee is made up of delegates from each House of Congress, one of whom was Representative Dingell, and so he was what we call a conferee, and he explained after the conference committee, in fact, after it was enacted, that they wanted this Endangered Species Act to be radical, right? Something drastic that was going to save all these animals and so forth. So they had envisioned that it would support injunctions, that projects would have to be forbidden or stopped and so forth. They didn't talk specifically about the Tellico Dam, but they knew there were things that agencies were planning to do, and they would have to scrap those plans. So this case presents, therefore, a question of post-enactment legislative history, and especially in light of what we're about to talk about, which is appropriations bills. So remember, I've said the legislative history is a sort of paper trail created in the process of a bill becoming law. But sometimes we have things even after it's passed, even after the vote, even after it's signed into law, then you have congressmen who were in these committees where the meaning was really discussed, or different drafts were considered and they settled on one, who come out and make public statements about what they were all thinking. And so the question is, now we have somebody telling us what they were thinking behind closed doors, but the statement is after we voted and after the bill. So that we call this post-enactment legislative history. Now let's talk about appropriations. This is where Congress gives money. And remember, the TVA was going to this committee and asking for money, and the committee really wanted the project to get finished. They wanted the dam to be completed. In fact, they specifically mentioned the Tellico Dam in a report when they kept apportioning money. So the court relied on the structure and overall tenor of the statute, which was, sorry about that, to support the idea that Congress meant the Endangered Species Act to be very protective of the animals. And so it was reasonable to think that maybe Congress intended to halt even an expensive, almost completed dam. Now, here's a highlight for you that I hope my students notice in the case. The court refers to these things we call canons of construction or traditional rules. Sometimes they may call it. And so these are not statutes or binding, but they're kind of rules of thumb that courts have followed for many, many years, going back through the common law era when they have to interpret statutes. And one of those is a rule disfavoring implied repeals. So let's say Congress passes a statute, and then a few years later, they pass another statute or amend another statute in a way that kind of creates a problem for the statute A. So now we have statute B that sort of cuts into statute A or cancels out part of statute A, but never admits that it's doing that. So this is sort of an implied amendment or an implied repeal. And now, don't get me wrong, there's times when Congress just straight up passes something that says we hereby repeal statute A from many years ago. It's no longer law, and it's removed from the law books, right, after that. But there's times where they just forget about it or ignore it and pass something, leaving us to maybe infer that they implied to either cut in or narrow that law or distinct or something, or maybe repeal it. Well, the courts have had over the years to develop a rule that this is dangerous ground to tread in. Otherwise, you could just always assume that get rid of any statute you wanted by finding later statutes. So they basically want Congress to spell it out if they meant to repeal an earlier statute. There's a similar rule about reading a lot of meaning into congressional budget allocations or appropriations or apportionments. And so the idea here is that every year Congress has to pass a budget, and boy, there's nothing Congress does that involves as many backroom deals and horse trading and political brinksmanship and compromises and so forth. Somebody trades one pork barrel project for another one in order to get the budget passed. And So the question is, if something gets defunded or more funded, right? At the time I'm filming this video, we have a big public debate about defunding police or giving more funding for the police. So the question is, if Congress increases the allocation or appropriation for an agency like the FBI or cuts their budget, should we read a lot of meaning into that when we interpret statutes? And again, the courts over the years have had to decide that this is kind of dangerous or shaky ground to tread on, and they're not going to do it. And they really want Congress to just spell it out. It's not that hard if you're passing an appropriations bill to just add a sentence or two saying, we hereby think that there should be an exception, like for the Tellico Dam, to the Endangered Species Act, that the court can work with, instead of having to look at the money that you gave to an agency and assume from that that there must be a silent or invisible statutory exception. Now, let's talk about the dissent very quickly. They make a lot of arguments, but I want to highlight just two for my students. One, the statute, the dissent applies to the, or invokes the absurdity doctrine and says, we have a really expensive dam, it's almost done, and you just want to throw it away, like never use it and completely waste hundreds of millions of dollars or tens of millions of dollars of taxpayer money. That's absurd, and there is no reason to think that that's what Congress wanted, that we would just waste a perfectly good brand new dam. They also point out that the committee reports from the different appropriations bill do say Congress intended the money to be for the dam after the enactment of the ESA, of the Endangered Species Act. So it's clear that at least the committee wanted the dam to be done, to be completed. But remember that the majority invoked this traditional canon saying that we presume Congress doesn't change substantive law or kind of create these implied exceptions to statutes just by giving money. By the way, what's the epilogue here? First of all, about the Endangered Species Act, it took a couple of years, but eventually Congress, in response to this case, so this case is the dam can't be completed, it doesn't matter. The statute says what it says, right? That's the holding we have in TVA v. Hill. So a year or two later, Congress says, well, actually, we really did want the dam to be completed regardless of the Endangered Species Act. So they just put that into words, which is what Congress wanted them, what the court, wanted them to do. The court, in the opinion, was like, look, if Congress wanted to create an exception for the Tellico Dam, all they had to do was pass that, enact that, throw in a line in the one sentence in the statute, and we wouldn't even be here. So a couple years later, Congress basically did that. Please, for my students, keep in mind, we keep getting cases about the huge economic losses due to the critical habitat designations under the Endangered Species Act. Okay, what happened to the snail darter? Well, the little population of snail darters near the Tellico Dam actually didn't make it. But in this later years, they started finding these little critters all over the place. And so the same fish popped up in other parts of the Tennessee River and its tributaries. And in fact, they were able to take some of those and transplant them to other rivers. So overall, the snail darter as a group is doing just fine, even if the ones near the Tellico Dam aren't there anymore. Okay, here's a review question to see if you've been paying attention. Can Congress repeal a statute or create a specific exemption to a statute by implication just through the allocation of funds to something that the statute otherwise prohibits? A, yes, congressional apportionments are a reliable indicator of congressional intent. In other words, this is the idea that Congress puts their money where their mouth is, and nothing shows us what Congress really wants as much as what they spend money on. Or B, no, courts traditionally have presumed Congress does not repeal statutes or amend them by implication indirectly through budget apportionments. This was supposed to be an easy question, and if you're not sure, you haven't been paying attention and really should rewatch this video. And that concludes our video about TVA v. Hill.